Good morning, everyone, and welcome to our March 2018 webinar for our Mortgage Quality and Compliance Committee. I'm very happy that you could be with us today. Hopefully you can hear the audio just fine. If you have any trouble with that, you do have the audio tab on the right-hand side that you can click and redial in if you need to. All participants are entered in mute, but you can ask questions of our speakers using the questions dialog box in the lower right-hand of the panel on your screen. So I'm happy to have you here with us today. We are going to get started. By the way, I should introduce myself. This is Susan Milazzo with the California Mortgage Bankers Association. Our committee co-chair, Monica McCarthy with Crosscheck, is also with us, and Monica will be introducing our speakers for our presentation on fair lending later on in the webinar. I'd like to go ahead and get started with a couple of event reminders for all of you. We have the California MBA has our first Chairman's Conference coming up on April 8th, 9th, and 10th, and it's going to be at the Lodge at Torrey Pines. This is for those who are at the C-level positions at our member companies. And if you have anybody at your firm that is interested in joining us, we have a great lineup of speakers and networking opportunities with the C-level peers set up. Really designed to be a very special event, an investment in those people that provide leadership in our companies and in the industry. Looking forward to that. We have on our Western Secondary Market Conference in July, our Mortgage Technology and Servicing Conference in August. So I'll be giving you more information on those events as we go forward. So our first event of the year was just last week, and that was our legislative day, and we had a great showing, great representation here in our state capitol of our members that participated in that day. And Pat Zenzla, who is our lobbyist, led some discussion on what some of our key bills are. So we're going to start off today's webinar with Pat talking about some of the key pieces of legislation that we're following this year. Pat, I'll turn it over to you.
Thank you, Susan. So first, just to start with where we're at in the legislative process, we're just beginning all of the policy committee. We have a few thousand bills that have been introduced. So the policy committees are going to be going through each of those bills. So there's going to be a lot of activity as far as bills that potentially could have an impact on our industry. I'm going to cover 4 of those bills briefly today. The first one is AB 2368. This is a bill that we are co-sponsoring, so we're supporting this bill. And what we're trying to do is we're trying to put in place a California remote notarization statute, so to allow for online notarization. We've seen similar bills and laws pass, and I think at this point they're in place in 4 other states, with several other states actually looking at doing the same type of thing. And so we're working with our industry stakeholders, such as the title companies, the notaries, the bankers, the credit unions, et cetera, trustees, to try to put in place an act that will allow for these online notarization and also to provide the protections necessary against fraud and to make sure that the process is still safe. So stay tuned. Right now the bill is in a very general form, but we expect the more substantive amendments to go into the bill to create the parameters for the program within the next week. The next bill I want to mention is SB 818, and this bill deals with California Homeowner Bill of Rights. At the end of 2017, provisions that deal with foreclosure prevention, alternatives, and modifications for consumers, statutory provisions that apply to lenders and servicers that have had over 175 foreclosures in the previous 12-month period. Those provisions sunset or expired at the end of 2017. And now everybody, whether you've had up to 175 foreclosures or more than 175 foreclosures, have the same set of rules with respect to California HOBAR and foreclosure alternatives and modifications. There is a consumer group called Housing and Economic Rights Advocates that are sponsoring a proposal to reinstate the provisions of HOBAR that sunset at the end of last year. At this point, we oppose the bill. We don't think it makes sense to reinstate provisions that have gone away. We've already created our policies compliance-wise to deal with the situation with them expired. And second, we have a whole set of robust requirements from CFPB on a national scale. So we are opposing this bill, and at the very least, if something does pass, trying to make it as uniform as possible and consistent with the CFPB national servicing rules. The next bill I want to mention is SB 1087. This is another bill that we are strongly supporting, and this bill puts in place, it builds on what we did last year to create a first time ever statewide regulatory regimen for PACE administrators. This bill actually extends the requirements and creates new requirements. It does things like create additional consumer protections, so there's going to be a new written enrollment program for PACE solicitors. These are the folks that go out door to door to solicit the energy improvements for the home, but also solicit the PACE financing. We're going to create much tighter underwriting standards for these PACE administrators in the financing and help to ensure that they do the underwriting and the ability to pay calculation before the customer gets obligated for the home improvements, the energy improvements. And then finally, there will be additional provisions for the Department of Business Oversight, their new regulator, to take actions against bad actors. So we think all of these new enhancements are real positives for the marketplace. And then the next bill I want to briefly cover is SB 1201. And this bill builds on existing translation requirements. If you predominantly negotiate in one of 5 specified languages, when you originate a mortgage, you have to provide a boilerplate form translated for some of the key terms of the mortgage, and the DBO, Department of Business Oversight, provides that form. This bill updates the forms that are used on the front end, and second, it would require that in addition to the origination of the mortgage, if you are negotiating in one of the 5 specified languages a modification of a mortgage contract, you also need to provide the modification translated. And at this point, the bill refers to all of the modification documents. What we're trying to do is get the Department of Business Oversight to use the same format they used for the original requirements, which is to create a translated form that licensees or financial institutions can pull down from the DBO site to utilize for the translation. So those are the 4 bills I wanted to mention.
Okay.
So, they're good, Susan. Thank you.
Yeah, thank you, Pat. Lots going on this year, and I think it's proving to be a pretty busy year from an election standpoint. For those of you that are on this webinar that might be following the remote online notarization issue in here and in other states, the California MBA is suggesting that the author of our legislation use the MBA ALTA model state language for our bill as a starting point. So as Pat said, as that bill goes through the process and more substantive language is added, we'll be giving you further updates on future calls. But I just wanted to make you aware of that if that's an issue that you were following. Thank you, Pat. We appreciate your help.
Thank you, Susan.
So next, we'll start with, we will continue on with our legal update, our litigation update with our attorney General Counsel Michael Pfeiffer. And Michael, if you would like, we can go ahead and get started.
Hi, Susan. Yeah, thank you very much. For those of you who have been on this call for, I guess for a long time, usually in this place of the presentation, I'm presenting to you a case or an administrative proceeding or some other individual activity. I've taken a different approach today because of what's happening in at the CFPB right now. Under the Trump administration, Mick Mulvaney has been appointed as the acting director of the CFPB, and he has put into place, he's doing a thoroughgoing internal review of everything that the CFPB is doing, and in particular the regulations pertaining to its operations and activities. And as a result, enforcement activity by the CFPB, I'm not sure it's been put on hold officially, but as a practical matter, it has. If you go to the CFPB website, and go into enforcement, usually you'll find examples of enforcement activity that's occurring. If you look there, there's nothing that's occurred since the beginning of 2018. Nothing that's published. No reported enforcement activity. And I've included a quote in the slide that from Mulvaney, where it says, "It's natural for the Bureau to critically examine its policies and practices to ensure they align with the Bureau's statutory mandate." This is fantastic. Trust me on this. They are doing a thoroughgoing analysis of what the Bureau is doing, how it operates, its practices, and in particular, the things having to do with its enforcement activities. And I want you to know that it's in-depth and it's thorough. And I wanted to give you a flavor of that today. That's what I wanted to spend my little segment here talking about. And I focused in particular on 3 requests for information that he has sent out. These requests for information are published in the Federal Register, and they allow 60 days for public comment. And you can make comments just going on, by email. And I encourage people to do that. I encourage people to look at these things and really take a look at it and get involved in it and make comments. The comments that are there are also published. You can see them. But I would think about making some comments on some of these things, because this is our chance to have input into some of the enforcement activities of the CFPB. So I focused on 3 of these. The ones having to do with the civil investigative demands, the rules of practice for adjudication proceedings, and the Bureau's enforcement practices. The responses are due within 60 days. The one for the civil investigative demand, that time I think has passed. That request was issued on January 18th. 60 days has passed. But the other 2, there's still time to make comments. The rules of practice for adjudication proceedings, that was issued on January 30th. And the Bureau enforcement process, that was issued on February 6th. So these are live, active opportunities for you to have input into the industry and how it's regulated. I'm trying to see, Susan, how I advance this slide. Thank you. The civil investigative demands is the first one, and I've just summarized that for those of you who aren't familiar with it. The way these work is the Bureau issues civil investigative demands to entities and persons who may have information relevant to a violation of the laws or any of their regulations. They require the recipients to provide the Bureau with all kinds of information, and typically it's some combination of written answers to interrogatories or written reports, documents, and even testimony. And you're required to produce these. They essentially are administrative subpoenas, and you're required to comply with them and provide the information that they then use against you in further enforcement proceedings. So the process of doing this is very important, and trust me, these things are incredibly onerous, and they really are one of the reasons why so many of these CFPB enforcement proceedings end up in consent decrees and people just basically rolling over and begging for mercy. Some of the things that they're asking for input on, and I've listed them here, is their process for initiating investigations, including the delegation of authority to the bureaucrats who are involved in this thing, as opposed to having them reviewed by some kind of a committee. their actual process of issuing CDs, the steps they can take to improve people's understanding of them, because sometimes they're very poorly drafted. They don't have the information in them that you need, and all ambiguity is resolved against you. The nature and scope of the requests that are included, including whether certain topics or requests should or should not be included. The time frames within which to respond. Usually these are very, very short time frames. And whether or not the Bureau can take testimony. Next slide. Could I have, yeah. In addition, their process for handling things that are inadvertently produced, and the rights governing witnesses, including statements that are being taken from witnesses, and they're also reviewing what kind of conferences can occur. This has to do basically with negotiations between the attorneys and the people who are the subject of the civil investigative demand. In the past, they've pretty much been totally non-negotiable, and they don't even talk to you. They don't even answer your phone calls. And then the Bureau's requirements for responding, including what kind of certifications you have to provide, what form the documents need to take, and how the Bureau responds to requests for modification or to setting them aside. So those are all open for discussion and input. It's closed now, but I mean, you should monitor this, because this is what's being considered. And it'll give you an idea of how thoroughgoing Mulvaney is in terms of reviewing the processes of the CFPB. Next slide. Okay, the next one is the rules of adjudication proceedings, and these are essentially the rules of procedure. If any of you have ever been involved in litigation, you know that there are rules of procedure that govern it. These are the rules of administrative procedure. And I've listed there some of the topics that are being, disclosed and that they're asking for input on, and you can still put input on this. And one of the things that they're asking for in particular is for comments on their process of resolving these claims, quote, expeditiously. The idea is they've foisted this on us that, these have to be resolved expeditiously. And yes, as a general rule, that's true, but you can get a little bit carried away with that, and that's what they've done. They want answers within 14 days. Normally in litigation, it's 30 days. In federal rules, it's 21 days. 14 days is a really short time period. They have all kinds of policies in place to discourage intentions. In other words, they get as long as they want to prepare, but then once they aim their gun at you, you got to answer within 2 weeks, and so they're reviewing those procedures. Next slide. I've listed some other ones here, including their ability, who can issue subpoenas. They in the past have strictly limited people who can they can get subpoenas on. They've limited who you can call as an expert. They've limited the number of witnesses you can have. They've limited what's admissible and what's not admissible, and they've limited discovery. So again, these have been very much kangaroo courts. And what's being considered is whether they should incorporate some of the rules of the federal rules of civil procedure into these administrative proceedings. Next slide. Finally, the last one I want to just mention is the Bureau's enforcement practices. These are some of the topics that they're asking for comment on, some of the questions that they're asking on, including, what kind of communication should be permitted between the Bureau and the subjects of the investigation, the length of the Bureau's investigation, and the opportunity to respond to the Bureau's notice and opportunity to respond. And sometimes they don't give you even that opportunity. They conduct the investigations and they don't even give you some indication that that's being done. So also they're asking for input on the calculation of civil money penalties, and the reason for saying the word including a possible matrix there is because there's been inconsistency in how they've calculated these things, and so basically they're considering making it very clear as to what those civil penalties will be and how they are calculated. And finally, also 6 and 7, some standard provisions and consent orders, and the way in which the CFPB coordinates its activity with other federal state agencies. So I gave these to you so that you can get a flavor of just how one-sided and, in my opinion, overly aggressive the CFPB has been in its administrative enforcement activities. This is an opportunity to say something about it. Pick any one of these or as many of them as your company wants and make some suggestions. Take a look at them, spend some time to get involved in them, and we heartily encourage people to express their views on this. That's my report, Susan. Thank you.
Great, thank you, Michael. I appreciate that. Yeah, lots of changes happening with our federal regulators. So thank you for that recap and encouragement for people to be following what's happening there. We're going to go ahead and turn now to this month's presentation. I will mention two things before we go into that. One, if you have a question, you can type that into the questions dialog box that is located on the right hand of your screen. You can just open that docking pane, type in your question, and we'll get to that at the conclusion of our presentations. And also, we are recording this webinar, and we'll make that recording available to you after today's presentation. Typically, we make them only available to our member companies, and going forward, we might go back to that. But for we're kind of in a time period for a couple of months. We're making all of our webinars that we do, not only on compliance, but on other topics, available to the industry, just as a resource and kind of letting people, a broader audience, kind of know the great content and information that we share. So with that, I will turn it over to Monica McCarthy, who is with CrossCheck Compliance. And Monica is a co-chair of our Mortgage Quality and Compliance Committee. She's going to be introducing today's speakers.
Thank you, Susan. Today our topic, as you know, is fair lending, and we have two speakers for you. The first one is Adrian Kleine, and second one is Ryan Stocking. So Adrian Kleine is with Morrison and Foerster. She's a partner.
Monica, it's Angela.
Oh, I'm sorry.
It's Angela Kleine.
Okay. Angela Kleine is a partner at Morrison and Foerster, and she's going to give us the outside counsel perspective, and then we're going to hear from Ryan with the in-house counsel perspective. So let me first give you a little bit of background on Angela. She's a partner at Morrison and Foerster in their San Francisco office, and her practice focuses on complex civil litigation and enforcement, with an emphasis on defending and advising mortgage companies like those of you on the line in matters involving banking, especially in fair lending, consumer matters, as well as UDAP. And many of us think of her as the diva of fair lending, and do recommend you reach out to her when you have fair lending issues. She's going to start us off with just a brief summary of the new rules and the areas of confusion, and then give you a brief update on enforcement, litigation, and reputational impact. Then we're going to hear from Ryan Stocking. He is the General Counsel and Chief Compliance Officer at First Direct Lending in Irvine. There, he oversees all of the legal, regulatory, litigation, licensing, compliance, and corporate risk matters for the company. He does appreciate the challenge of building and enhancing compliance management systems. And it's been said that he does suffer from a love-hate relationship with HMDA. So in his experience, both at First Direct and at other lenders, investors, and servicers, he has developed a strong background in fair lending. So we look forward to hearing his wisdom and comments from an in-house perspective today. He's going to speak on implementation and compliance considerations and challenges that you've all been facing with regard to the new rules. So with that, I would like to turn it over to Angela to get us started.
Thank you, Monica, and thank you, Susan. And I did just email my marketing department to include the phrase diva of fair lending in my bio.
Seems appropriate.
I like it. And thank you, everyone, for attending this webinar and an always interesting and evolving topic. So as many of you know, the mortgage industry is at the heart of the most important economic transaction that most people make in their lives, and that's buying a home. And at the same time, fairness and equality continue to be issues that are at the forefront of the national discussion. Recent events make clear that discrimination and bias still remain issues that we haven't solved as a country. So regardless of who's in office, there remains a focus on compliance and doing the right thing by customers while, of course, at the same time, also defending against claims that lack merit. So today, we're going to give a brief refresher and update on the latest in fair lending law and compliance. And that, of course, includes several federal and state laws and regulations, including ACOA and the Fair Housing Act, as well as Ryan's favorite statute, HMDA. There are, as an overview, two primary theories of fair lending liability. The first is disparate treatment, which may be overt, which is what we think of as your most obvious fair lending violation when a creditor or their employee openly discriminates on a prohibited basis, which hopefully you all very rarely or never see in your daily business. Or regulators take the position that disparate treatment can also be found through comparing the treatment of applicants who receive different treatment for no other discernible reason. And there's no need for a specific intent to discriminate. For example, we've seen several credit card settlements over the past year that maybe you haven't noticed because they don't apply to mortgage, but the logic could apply. We've seen several credit card settlements that were driven by zip code limitations in U.S. territories where different products were offered because of just system limitations. And there, the government took the position that that was disparate treatment and not disparate impact. And that matters because the burden of proof is different. So in disparate impact cases, of course, you have this test, which is relayed on the slide, that's a burden shifting test, which in more detail, of course, I have trouble using my keyboard, but there we go. In more detail, the way that a disparate impact theory works, and this is the Fair Housing Act rule, but you see the same thing in ACOA cases, where the plaintiff has a burden of showing that a facially neutral practice actually or predictably results in a disparate impact, and the burden then shifts to the defendant to show that the practice is necessary to achieve a substantial or legitimate business interest. And then the burden then shifts back to the plaintiff to show that that interest could be served by some other less discriminatory effect. Of course, in reality, as anyone who's gone through a fair lending exam knows, in the enforcement context, what really happens is that the regulator identifies that statistical difference in pricing or approval or denial rates, and also identifies a policy that it doesn't like, and then there's a demand to change that policy and eliminate or reduce those statistical disparities that you see in the data, or face public enforcement action. So while this test remains important, especially for private litigation, I think in reality we often just remain focused on what our fair lending data shows, as Ryan will discuss in more detail. Of course, as Michael aptly covered, the CFPB does not have the same focus this year as it had in the past, and a fair lending presentation is very different than it used to be because we're not warning you about Director Cordray's latest statements, but we do still see some enforcement and litigation going on that I'd like to update you on. This past year, there was one major fair lending consent order issued, and that the CFPB was not a part of, but the DOJ was. The now departed SDNY attorney Preet Bharara, this is one of his final actions in the job. He settled a really long-running matter about wholesale lending going back to 2006, and this is your typical fair lending settlement alleging disparate rates and fees on loans to African American and Hispanic borrowers. It involved practices that I think are no longer standard practice, at least for large lenders. The DOJ alleged that rate sheets given to brokers allowed discretion to deviate on loan price beyond the outcomes you might see based on objective credit characteristics. And of course, regulators hate that kind of delegation of authority to brokers. Buried in there, though, was something that I think remains relevant to us, which is the claim that the bank monitored its fair lending data in the wholesale arm, and it knew of disparities, but it failed to address them. Now, of course, I doubt that that is the whole truth, but nevertheless, it points to the importance of not only monitoring for statistical disparities in your fair lending data, but also addressing them in some way. I know it can be very hard to do a regression analysis and see disparities and then figure out how to bring them down when you can't identify a specific reason for them. But at least as far as the DOJ goes, it emphasized that it was important to do something about those disparities that the bank saw. And just touching briefly on the CFPB point, though, later, a couple months ago, of course, there was a well-publicized email by Mr. Mulvaney that essentially stripped the Office of Fair Lending of enforcement authority. And of course, the CFPB still has fair lending enforcement authority, but it removes this kind of very educated and powerful arm of the Bureau from the enforcement wing, and enforcement is now under the same supervision, enforcement and fair lending division that all other enforcement is. So you'll continue to see fair lending enforcement in the future, at least theoretically, but it doesn't have the same focus that it did under Director Cordray. And I think it's also notable that although you haven't seen much fair lending enforcement this year by the CFPB is still doing its job. There's still exams, and there were, at least prior to this current hold, several mortgage industry consent orders under the current administration, including a real focus on RESPA, servicing and foreclosure, as well as student loans and other actions. So the Bureau is still doing its job, although I completely agree that it has stepped back and is reassessing at the moment. Another interesting issue that I just wanted to flag, because I think it's really interesting, and I'm into consumer reporting, but I think it's also, in the future, will be interesting to the mortgage industry, and that's alternative data. So the mortgage industry as a whole isn't quite ready, I think, to be using alternative data, although some of us are, and I get that, but it's gaining reliability and respectability, and you saw that in 2016 and 2017 where the CFPB issued requests for information about the use of data aggregation services and the use of alternative data in making lending decisions. And then late last year, you saw the CFPB's first no-action letter to a lender that used alternative data. The lender was Upstart, and it was offering consumer credit, but still, I think the notice of no-action letter is interesting because it tends to suggest that companies may have some flexibility to use alternative underwriting modeling, which is good news for consumers who may not have a traditional credit profile, and it's good news for lenders who are interested in expanding the envelope to those lenders. And finally, the big enforcement update that we saw this year, and I think this is the first time I've said this in a fair lending update, was a big HMDA enforcement action. For the first time, we saw a six-figure HMDA enforcement action that was purely about errors on a HMDA LAR. It was in some ways, exceptional circumstance. You saw a lender that, at least from the CFPB's view, experienced some growing pains, and as a result, received a rather large civil monetary penalty. There was some guidance in the consent order that I think is helpful, though. Among the things the Bureau noted that it wanted to see, at least from a lender of this size, and NationStar was, I think, the 9th largest lender during some of these years, were the following. Maintaining detailed and centralized HMDA data collection and validation procedures. And it emphasized you really need more detailed and available procedures, not just general procedures, but detailed ones. Clearly defined and consistently defined with specificity employee roles and responsibilities over HMDA. The performance of formal compliance tests, audits, or transactions. The consistency of data definitions among different lines of business. And boy, I mean, I'm sure, Ryan, you can speak to that in more detail, but the CFPB was hep to the fact that when you have different data definitions used in different lines of business, because you have system limitations and historical reasons for that, it can lead to real HMDA challenges, and the CFPB noted that in this consent order. And finally, it noted the importance of vendor management, which is always a CFPB bugaboo. So in addition to enforcement, I just wanted to note that on the horizon, of course, we have new HMDA data, and I'm not going to walk through all of this now because we've all done tons of HMDA training already, but in red you have these new pieces of data that are going to be public soon. And when you have all that new data, that's really the secret sauce of our fair lending regression models, the kind of things that we use to explain why there really aren't statistically significant disparities. That's all going to be out in the public domain now, or at least available to regulators. So when you combine that with the new data fields and new procedures and formats, I think you're going to have a lot more transparency and you're going to have room for error, which could lead to more HMDA enforcement and could lead to more fair lending enforcement. Although, of course, if your data is clean and you're monitoring it well, it could be a positive as well. It just depends on your perspective. In addition to enforcement issues, we've had some interesting litigation updates over the past year. One of them is, reflecting a sea change in how we view sexual orientation discrimination in this country. Several courts of appeal have reversed themselves and held that, contrary to prior orders, at least under Title VII, sexual orientation discrimination is one flavor of discrimination on the basis of sex. So these opinions, like the Zarda opinion in the Second Circuit that I note here that just came out last month, could very well support an argument that a COA's prohibition on discrimination on the basis of sex also includes discrimination on the basis of sexual orientation. It depends where you are, and as far as I know, the Ninth Circuit hasn't ruled on this, although I think we can make guesses about where it might go. Maybe someday the Supreme Court will take it up. The government is no help. The DOJ files an amicus brief in the Zarda case arguing against the plaintiff, while the EEOC filed an amicus brief in support of it. So who knows? I think if we had to predict where the CFPB director and the current administration would land, I guess we would all guess that he would side with the DOJ. But nevertheless, I mean, I think as a matter of public relations and a matter of legal risk containment, discriminating on the basis of sexual orientation is probably not a good idea wherever you are at this point. We've also seen continued litigation on the calculation of family leave and disability income. As many of you hopefully know, there's been guidance for a long time now, and several settlements over the past 3 or 4 years about considering parental leave income and disability income. But HUD says it continues to see a steady stream of complaints, and even this HUD administration is interested in making sure that disability and family leave income are calculated correctly. So these cases that you continue to see filed really make clear that it's important to have specific underwriting policies that cover the scenarios that you see around family leave income and disability income to avoid underwriter error or confusion. And finally, another big set of fair lending litigation that continues to march on is litigation against larger lenders that are sued by cities and counties alleging discriminatory mortgage lending. Some banks have succeeded in these cases as the cases have slowly marched on, including Wells Fargo getting a win in the Ninth Circuit this past year, while others continue to defend their cases, and at least one case filed recently by the city of Philadelphia alleging that steering of minority borrowers into disadvantageous loans somehow resulted in the loss of revenue to the city. So against this backdrop, we still see that a solid fair lending program remains a priority. And as Monica and Ryan will discuss in more detail when I hand it over to them in a second, I think we can all agree that prevention is still the best measure against these legal and reputational risks. So with that, I'll turn it back over to Monica. Thank you.
Great. Thanks, Angela, so much. Appreciate those insights. Now we're going to turn it over to Ryan, who's going to give us some of that in-house perspective on some of the challenges that he has faced, but also in discussions with others, some of the challenges that are out there, and we really want to hear some wisdom on how these things can be solved, Ryan.
All right, thank you, Monica. I thought it would be easiest if I just sort of made the assumption that everyone is either building their fair lending program or trying to review it and refine it. If you have your fair lending program all wrapped up, then congratulations, you can go to lunch early. But I know that a lot of the places I've worked have, as I've arrived, I've needed to dive into it just to make sure that I have an understanding. If you're part of a company that's in the middle of growing, then you may be acquiring new business channels, so you need to see how those impact your fair lending program. Or if you're part of a company that's shrinking and you're contracting and you're taking on more responsibility, maybe you used to not have to deal with fair lending at all, and now you're suddenly in it. It's something that you probably want to pay attention to. So I thought just putting together some of the steps in building or refining your fair lending program would be useful for the audience. This first slide is just really a table of contents, more or less. Important to go through and check your policies, your procedures, data integrity, risk assessments, monitoring and audits, and then understanding your legal and regulatory risks. As far as policy review, you want to ensure your company policies are well documented, up to date with current requirements, and reflect the company's intent. Understanding where the company wants to be and understanding their business model is paramount to making sure that it makes sense. I know that as the CFPB came into existence, a lot of folks used off-the-shelf policies and procedures, and they've sort of refined those over the years, but they may still have some of that generic language that does not apply to their company at all. So it's important to go through those and make sure that those make sense with what the company is currently doing. Also making sure that the staff is familiar with the policies, that they have access to them, that they understand why those policies are in place. And this goes hand in hand with just training, as will the next slide discussing procedures. And then making sure that the legal and compliance departments are able to clearly explain policies to third parties. If those departments are separated, legal obviously to deal with litigation, compliance to deal with regulators. Policies to review outside of just your fair lending policy, ECOA, HMDA, the MAP rule, TILA, pricing exceptions, underwriting exceptions, just making sure that those are consistent with your fair lending policy. One of the things that I think is important to pay attention to is any policy that allows for some sort of discretion, because that is a red flag for any regulator or plaintiff's counsel to look for and try to figure out if there is a potential for fair lending violations. Part of this just policy, especially within ECOA, HMDA, TILA, is just deciding what your definition of an application is for HMDA purposes, because the HMDA data is what is likely to be used for any sort of fair lending review. And depending on what your business model is, and Angela, referred to the NationStar situation, their consent order, they had multiple business channels. It's a very different process from a call center where you're trying to define what a HMDA application is, to a brick and mortar branch model application, to a wholesale lender defining what an application is. If you have all three of those, you have to figure out a way to marry that data, because a call center will have a lot more applications that come in, and or at least touching consumers, that will end up falling through the cracks. People get called by 30 lenders within 10 minutes of submitting something online, and you'll end up with a lot of withdrawals. And so trying to figure out where you define application for those purposes makes a significant difference and could skew your data one way or the other. So it's important to just understand what your company, how your company is defining application, and then how they're defining all of the other elements that go into this fair lending process. As far as procedure review, want to make sure that your procedures are aligned with your company policies. confirm again that the staff is familiar with the procedures. You can do this through training and through just being out on the floor and sort of monitoring them. And then make sure legal and compliance understands procedures that you want to focus in on are application and denial withdrawal. So making sure you understand the process that is followed to deny someone, make sure that you understand when adverse action notices are being sent out, how they're being sent out, lock and price exceptions, policies regarding those, making sure that if there is discretion, what sort of discretion is allowed, how well is that documented, how easy is that to obtain once the file is closed? Is it in the system and pretty clear? Are there, decent notes in the system to be able to ascertain what's going on with the file, or is it just clicking radio buttons and hoping that no one pays attention to all the different exception reasons? Underwriting exceptions, same type of thing. If you are allowing underwriting exceptions, you want to be able to track those. And then advertising, review, and approval. You want to make sure that you understand what the marketing department is putting out there. Different for depending on what your business model is. If you're a call center, then you typically have that centralized and it's easy to monitor advertising. If you're a brick and mortar branch model, then you've got a bunch of independent or individual branches that are out there trying to pound the pavement, and maybe they have some leverage to use stock advertisements, and you need to just keep your eyes on those and be reviewing those on a regular basis. So really understanding your business model and understanding the company that you work for is important. You also want to understand your customer acquisition practices regarding advertising. You could, have everything fine and you're reviewing everything, but your mailers only go out to affluent neighborhoods, or your billboards are only posted in affluent neighborhoods. So you want to make sure that you understand where the customer acquisition is occurring, so that you have a clear understanding of why your data might end up looking the way that it does. Once you've gotten through the policies and procedures and have a clear understanding on those, you want to move into data integrity. Make sure that you establish a source document, or that you have reviewed your source document chart if you already have one. Understanding which documents are going to be the source for your HMDA data and how those documents may change throughout the course of the process. For income, obviously on the 1003 at the time of initial application, that's the only place you'll find income, but income changes throughout the process potentially as you receive income documents from the consumer and you get to the point of underwriting and you're calculating income. Could be a very different number by the time you close and you have your income information with the funding of the loan. And that could have fluctuated throughout the process. So understanding the different milestones within your process and being able to identify what document is important to capture at that time, and then understanding how the system is going to capture that. So system enhancements and limitations. There could be systems that are limited with their ability to track the various data fields, especially if you have customized or bastardized the systems to try to configure with your specific process. Making sure that you are capturing that information. So my example of income, if income is changing throughout the process, you need to have some sort of snapshot so that you can identify, okay, at this point in the process, at this milestone, this is what income was. And then it's easy enough to grab all of the data on funded loans, and companies are typically very good at that. It's the loans that don't fund that you end up struggling to try to figure out what the data should be and what documents you need to rely on. You also need to be careful about systems relying on other systems, making sure that if they are impacting each other and overriding data, that you understand how that functions. I know just some lead generators, if they're built into the system, they can pass information straight through into the system. And so that is auto-populating, and you may not know why that's populating the way that it does. Pricing engines can overwrite certain information, potentially. Compliance engines could overwrite information within the LOS. So making sure that you understand how those function and making sure you understand the impact that that may have. And so again, trying to make sure that you are snapshotting information and understanding where it's coming from. Once you have all of the data and you feel that it has some integrity and it's solid, then you can finally do some decent fair lending reviews and start preparing your fair lending program for what it should be, and not just focusing on the data alone, and making sure that it's clean. Performing a fair lending risk assessment is important, especially initially, understanding what products you have, understanding your process, understanding who your customer base is, and then making sure that you are focusing in on those riskier areas to monitor and audit. And then performing those risk assessments on a regular basis. If you introduce new channels, if you introduce new products, making sure that you are performing those risk assessments. On the monitoring side, you want to establish a process, frequently review the data for comparison with files. This is just for the data integrity piece specifically, making sure that your source documents are accurately reflected in whatever reports you're pulling for the data. That has a tendency to go a little bit sideways every time there is a release from IT. And so you want to make sure that you are keeping up with that, because you don't want to get to January of the following year and go to look at your HMDA data and find out that it is all skewed because there was a release in March that changed one of the fields that you weren't aware of. And if there's those slight changes, then that data, that HMDA data, is going to mess with your fair lending data. Pull reports from the LOS just to look for abnormalities and anomalies, picking up on outliers, things that don't make much sense. If you've got, people who, consumer who only makes $10,000 a year but is applying for a $5 million loan, that might be a little bit sideways. There might be some fat fingering there. It could easily be somebody who makes $100,000 and is applying for a $500,000 loan. So making sure that you're just, again, this is more data integrity stuff, just to make sure that the data that you are putting in is accurate and makes sense for your business. Regularly review advertising materials to confirm compliance. So not only reviewing it as it goes out or prior to it being released, but especially for the brick and mortar type models where there is some, ability for the branches to do their own advertising, making sure you understand their advertising practices and the materials that they're using. A review of where these marketing materials are being distributed is really useful. Just understanding which neighborhoods these ads are going out to, both the method and the mode of advertising is important. And then I wrote consider using third-party fair lending software, but that's, really only consider using it if you don't have your PhD in like data analytics or quantum statistics, because you need to use some sort of third-party fair lending software if you want to get any sort of fair lending detailed analysis of your data. If you're capable of doing regression analysis on your pricing and underwriting models, then you I don't know why you're in a mortgage company unless you're hired specifically for that. But the software that's out there is really, really useful for this and is built for the mortgage industry, helping us to identify match pairs, do the match pair analysis, do the regression analysis for us so that we can focus in and look at the individual files to try to figure out what the issues are. Getting into any of these fair lending software programs, depending on what your business is, and this is again just understanding what your business model is and how it works. If you have a very simple business, you may be able to use third-party fair lending software right out of the box and not have to change anything. A lot of these are customizable, where you can enter in a bunch of information to customize it to your business model, but that takes a lot of time. So that may require an additional person. You need to have a fair lending person. And I know in a contracting market like we appear to be in, it could be that you don't have those resources. You don't have somebody. So the alternative of having the fair lending software yourself is to engage some third-party auditors or consultants. And so potentially running audits and having them review your fair lending program as a whole, in addition to performing some of the detailed analysis of the data. Of course, you want to be on top of this, so monitoring is absolutely the best practice. But if you can only afford to do it as infrequently as semi-annually or annually, at least you are getting a look at it. Being on top of it is uber important to make sure that you don't run into any issues later down the line where you could have captured some of the problems up front and corrected them, and now you're down a path that you can't come back from. Legal and regulatory risks. On the legal risk side, I have consumer advocate groups, and really this is sort of both the same thing. With the expanded HMDA rule, there's more transparency, which means more opportunity for groups to skew the data in their favor and bring actions against lenders. And this is all just about perspective and the way that you can slice the data. Same thing with class action lawsuits, which could be brought by the consumer advocate groups, I suppose. And so just understanding that you need to have this perspective. That's one of the important things about using the third-party software or third-party auditors, is that they can give you that third-party perspective. They can look at it through a different lens and explain to you why they think that your data is maybe a little bit different than what your understanding of your data is. And so making sure that you're looking at it from multiple angles is really, really important to make sure that you are prepared for anything that may come your way. At the end of the day, you need to be able to say, look, we've got a solid program. We understand what our data says, and we've got all of these controls in place to make sure that there aren't any anomalies or abnormalities that occur. On the regulatory risk side, CFPB fair lending exams, this was maybe different a year ago. Angela spoke about it, and even Michael spoke about the changes at the CFPB. I think the changes made by Mulvaney, they should have a significant impact on the way that we approach CFPB fair lending exams going forward. I think I don't think that they're any less scary than they were before, but I think there will be more cooperation between the two sides going forward, or at least during this administration. Data set requests, I put this in here because I know before the new HMDA rules, there was what everyone referred to as HMDA plus data, and it was a few additional fields in addition to the fields that were reported on the LAR. And what the CFPB would send you for a fair lending exam was a list of 130 fields that some you had never even thought that you had never considered tracking or validating. And so I think this potentially, with the expanded HMDA rule, it gives you an opportunity to understand what they're going to come in for and what they're going to be looking at, instead of just blindly trying to figure out what data you can pull from your system that matches up closely to what they have requested. So I think it's maybe a benefit. In the same vein, they could still come and ask for additional fields that you haven't thought about. So as much as they are providing you the playbook, they still have some cards up their sleeves, or at least they used to, as far as I felt. And so you just want to make sure that you are prepared for whatever they have. It's because if you are working with some of these outside consultants or auditors, they should have a good sense of where the CFPB is going, and they can give you some insight into what's happening with some of your peers, some of the other entities that are out there. And then state exams, I put this in here just because they at least one state does do some HMDA review and has their own CRA requirements, and they have their own interpretations of the rules. And so making sure that you understand the various interpretations that some of the states may have compared to what the CFPB may have, compared to what consumer advocate groups, state AGs, Department of Justice, making sure that you understand how they are approaching those and being up to date on what sort of actions they're taking is important. Finally, I put a list together of just some best practices. I recommend formally documenting the fair lending program, putting together all the relevant policies, procedures, desktop procedures, guides, process flows, charts, training materials, monitoring reports, and audit reports in a single location. I think that gives you a total picture of what the program is and allows you the opportunity to really see how everything works together. If you look at these just individually, then it's tough to understand the big picture. The next one was integrate your fair lending program into the compliance management system, applying the same framework to the program. So I talked about policies, procedures. I mentioned training. You want to make sure that those are all in line and updated frequently, and that they're applied appropriately. You want to have monitoring. You want to have corrective actions. You want to make sure that you're tracking fair lending complaints. If a complaint has a mention of fair lending, then you want to make sure that that gets escalated or is handled and tracked in a different way, or is at least identified by the company so that you can pick up on any trends that may occur there. Or I guess unveil a bigger problem that could be just under the surface. You also want to make sure that you've got audits coming in on a regular basis to look at your fair lending program. And you want to make sure that the board or senior management is aware of what's going on within the fair lending program, and that they, at least on an annual basis, are updated on the status of the program. Continuously review the program, try looking at it from different perspectives. I mentioned this earlier, or hire a third party to provide that perspective. And then my final one was become best friends with the IT department, especially if you are just monitoring on a really regular basis. Being able to get them to make simple changes real quickly during their downtime, which they don't have any of, can be really useful in just making the slightest impact and correcting something before it becomes a much bigger problem. Monica, that's all I got.
Okay. All right. Well, thank you very much. We appreciate the information, Angela and Ryan, for really valuable information on HMDA. I know that that is, an issue that a lot of our members are have a lot of questions around. So let me take a look at some of the questions. I think we've answered most of those. Again, if any of you have any questions for Angela or Ryan, go ahead and use the question dialog box on the right hand of your screen, and we will get those answered. Always a sign of a good presentation. You've gone over everything. I will take a moment to let all of you know, and as we're waiting for possibly some more questions to come in, our next month's webinar will be April 26th. That will be on tax reform, and we'll have from Jeff Spiegel with Spiegel on that topic. Lastly, if you were forwarded this information on how to register for today's webinar and you would like to receive information from us directly, go ahead and send me your email information. I'm at susan@cmba.com, and we'll be sure to add you to our compliance webinar distribution list. That concludes today's webinar. Again, thank you for all of your participation, and to our speakers, and everyone have a great rest of the day. Thank you.